we're together, and so let's make the most of it and get started. So thank you everyone for joining us today. My name is Max Bookman. On the call with me is my partner and father, Robert Bookman, and together we make Pazetsky and Bookman along with our amazing team of paralegals. We're a family business, been in business for over 30 years. And for those of you who don't know us, we represent bars, restaurants, nightclubs, all facets of the hospitality industry in a variety of regulatory issues, but focusing primarily on alcohol regulation all throughout New York State and New York City. But one of the things that we're most proud of doing is being founders and counsel to the New York City Hospitality Alliance, which is why we're here today. The Alliance is, before COVID, was an absolutely critical organization. And since COVID began, the Alliance has become indispensable. We have been on the front lines of every major regulatory discussion, negotiation battle there's been since COVID began, trying to advocate for the needs of bars and restaurants, take it from the Open Streets program to in outdoor dining to alcohol to go, any major regulatory issue that's come up during COVID, the Alliance and our firm have been on the front lines of it. And so it's a privileged position that we're in. It's a position that we're grateful to be in. And because of that, because of the number of questions that we get, we thought today would be a good opportunity to talk to folks about the current state of play in food and beverage regulation in New York City, go over some of the rules that have been developed, some of the issues that we've spotted, and then we're going to try to reserve as much time as possible for questions and answers. Before we get going, and before, unless Rob has some additional opening remarks I might give to him in a minute, I just want to say, we had over 300 people sign up for this call. And I think that's just a testament to how seriously people in our industry are taking the COVID rules, and how much of a desire there is to do the right thing. New York City is the food capital of the world. It always has been. We want to maintain that position, but we've also have a reputation for doing things right in New York City, for compliance. And I think the number of people who've been interested in today's call just demonstrates that there is a real desire out there to make sure that you know the rules and that you're doing them right. So before we get going, Rob, do you have anything you want to add?
Yeah, I just want to say that we've been doing this type of presentation with some community groups and some neighborhoods, and there is a real thirst out there for information to ensure compliance. And having worked with this industry for so many decades, I'm not surprised. We're a very responsible industry. We want to always do the right thing. Over 90% of you get A's in your health department, letter grades. That's not a surprise to us. And even in the last few months, with the very changing goalposts of COVID rules, constantly being updated, constantly being changed, with no notice to anyone, other than check a website regularly. We're still proud that with the thousands and thousands of inspections that have been done of premises, there was never less than 90% compliance in New York City, and more recently over 99% compliance in New York City. That's not to mean that there aren't a lot of questions that people have, and so we hope to spend some time going over a lot of the normal kinds of regular questions that we get on a regular basis here at the Alliance and at Pazetsky and Bookman, give you some of our experience, or what we consider to be best practices above and beyond, the actual rule, and then again to take your questions about particular situations that you need some guidance on. We'll also be available, either through the Alliance or directly by checking our website and emailing us afterwards for further follow-up.
So for those of you, we're 5-something months into COVID now. I assume this is not anyone's first Zoom call. There's a Q&A function on the bottom of most of your screens. You could use that. to ask questions. We already see some questions coming in. We're going to go through just some initial topics that we wanted to talk about, which we think will be relevant to everybody, and then we'll try to get to as many questions as possible. So as we go, if questions come up, please use the Q&A function down there to ask. And with that, let's get started. So the first thing we just want to run through for everyone is the current state of play with F&B regulation in New York City and in the state. So you do not need to be an attorney for an industry trade association to understand that the state is really running the show right now when it comes to F&B, especially bar and restaurant regulation in New York. And right now, the governor is running the state. And so in terms of the important players out there, everything that we're seeing that regulates you either comes from the governor or runs through the governor in some way. At the city level, people are involved, but but really everything starts and ends at the governor in New York. And that's been that way for months, and that shouldn't come as a surprise to anybody. And because of that,
with the obvious exception of outdoor dining, which is a city program with state coordination, and those inspectors who have been, frankly, rather cooperative after the beginning are city inspectors.
Yeah. And so because of that, and because the governor has taken a great interest in bar and restaurant compliance, especially in the city, we've seen a drastic increase in the number of inspections of bars and restaurants since COVID began. And we've seen a lot of resources being deployed and made available to the State Liquor Authority to perform its alcohol inspection. So if you're a bar or restaurant owner, there's really one of two different types of inspections you may get these days, and we're going to talk a lot more about that later in the call. One of them is your typical State Liquor Authority inspection that you may have gotten before COVID began, where an investigator who is an employee of the State Liquor Authority, they come to your premises, present him or herself as an investigator, and inspect your premises not just for compliance with the COVID rules, but the full panoply of alcohol-related rules that the Liquor Authority enforces. Things like making sure your alcohol is purchased from legitimate sources, that you're complying with your floor plans that the Liquor Authority has on file, any number of things. And people are getting those inspections. Additionally, however, because of the amount of resources that have been made available to the Liquor Authority due to COVID, and this comes from the governor, there are inspectors from other agencies, other state agencies. We're seeing state police, state DMV, or highway, other state agency inspectors who don't really have a great deal of experience inspecting bars and restaurants. They've also been deployed to inspect bars and restaurants in New York City. And they're not nearly as experienced, obviously, in the alcohol laws. And what they're looking at generally is less the normal things that SLA inspectors look at, and they're generally, in our observations, focusing more on the COVID-related rules. So that's what's happening right now on the state level. Many of you know this and are familiar with this, and because of the increase of inspections, we're seeing an increased number in violations, or if not violations, concerns amongst people about how to avoid violations. We have clients who called us and told us, I've been open for 5 years. I've maybe gotten, 3 inspections during that period of time, but in the last, 2 months, I've had 5 inspections or something like that. So, even if you're not getting violations, you're getting inspected more, which is raising the need to understand what your COVID obligations are. And so we'll talk about that. Just the other point, you have anything to add to that, Rob?
No, that's good.
Okay. So the only other point on sort of overall basic state of play that we wanted to get in on this call before getting into some specifics is, of course, indoor dining. That's something that's on everybody's mind. I think that is the number one topic that people ask us about, is when are we going to have indoor dining in New York City? And rightfully so.
So let me jump in on that.
Sure.
So obviously the Hospitality Alliance is intricately involved with that issue. We have been pushing the agenda on that issue, and as a result of that, We have been pleased to see that as of last week, the Speaker of the City Council, Corey Johnson, publicly came out and called for immediate opening of indoor dining in New York, as with the rest of the state. That has caused a tsunami of other elected officials to do the same. And daily, there is virtually daily now, there is another borough president, another state elected from New York City or city council member who is joining that. We think that pressure is going to ultimately result in the governor and the mayor having to come to an agreement on allowing indoor dining. If you haven't made your voice known on this issue, you really need to through emails or reaching out to your elected officials, because ultimately that's going to be the fastest way for us to get open. We have to get open. There's no reason to discriminate against New York City restaurants. There is no bubble over New York City. You guys know how to comply with the law. There's no difference between 50% occupancy in a restaurant in northern Bronx versus 50% occupancy of a restaurant in southern Westchester. One's allowed, one's not. So outdoor dining, while it's been great for the 10,000 places that have been doing it, it was never meant to be a substitute to be open indoors. The rest of the state has been open for 2+ months already indoors. Thousands of restaurants, tens of thousands of people having been served safely. We know we could do that here in New York as well. And I just received a text, so I am free to announce because we were embargoed up until now. But we've been integrally involved in the last 48 hours in negotiations, and while I should say discussions. It really wasn't a negotiation, but it was discussions. The governor is, as we speak, making an announcement right now concerning having come to an agreement with the mayor about opening indoor dining in the city of New York. I don't have the details because, again, it wasn't a negotiation. It was a consultation in which we stated our opinion and told them you will need a time frame and we need something, and it's being discussed right now publicly. So I'm sure by the end of the day, the Alliance will have an alert going out saying what it's going to be, when you're going to be able to open inside. But we anticipate it will be soon. So that's good news.
So breaking news, you heard it here first.
Breaking news.
Indoor dining in New York has been announced and is coming, and details will follow. Something that we've been advocating for a while and have been involved with the discussions. So with that huge piece of news out of the way, let's focus on what doesn't really change by the indoor dining announcement, which is what violations are there in the universe of potential violations to get, and what happens when you get one, and then talking about some best practices to avoid getting a violation. So first, we just want to make the procedure clear to people. Either this is relevant to you if you either have gotten an SLA violation and you want to know what comes next, or you're trying to avoid getting an SLA violation because you want to comply with the law, but you want to understand what could potentially happen if something does go wrong and you get one. So there are two different paths for you folks to know about. One is what I call the normal path, and the other is what's called getting a summary suspension. And we can talk about both because both are happening. And both have been happening before COVID, by the way, as well. So the normal path for getting a violation is an inspector comes to your premises, or otherwise the liquor authority is made aware some other way that a violation took place. And the liquor authority issues you a document called a notice of pleading. Some people call it an SLA ticket or an SLA summons. Its official name is a notice of pleading. That's what it's going to say on top of the document when you get it. And that document is going to be given to you in the mail. It's going to come to you, the mailing address that the liquor authority has on file for you. And that document is going to list charges. It's going to say what you did wrong. It's going to give some basic information about what you did wrong. This could include COVID-related charges or not COVID-related charges. Once you get that notice of pleading, it'll have a date on it. And by that date, you'll have an opportunity to either respond to it saying that you think you're not guilty and you think that they got it wrong and you want to go to an administrative hearing where you think you'll be able to prove that you're not guilty. Or what happens in more cases than not, you respond by offering to settle the charges. And when we say settlement, what we mean is that the liquor authority, in many cases, will offer right there on the notice of pleading a pre-printed fine that you agree to. You plead what's called no contest, which is in many respects essentially pleading guilty. You agree to a pre-negotiated fine. Before COVID, for the vast majority of violations, it happened in that normal procedure, the way that I just described it as. And ever since COVID began, we've seen those types of violations as well. And so while all COVID-related violations are serious, there are some like, for example, if the only thing they saw was, one employee not wearing a mask and that's it, then, every case is unique, but more likely than not, you're going to just get regular charges in the mail. And during that whole period of time, while you're reading the charges, responding to them, and potentially settling them, you're allowed to be open, operating, and serving alcohol. But what's much more disruptive to a business is the other category of charges, and that's called summary suspensions. And if you own a bar or a restaurant, that is probably something that you're not familiar with, or at least you weren't familiar with before COVID. And that's because before COVID, it was fairly rare to see a summary suspension. They happened, but it was typically reserved for the worst of the worst cases. There was a shooting that happened the night before, and the place has a history of shootings. What a summary suspension means is that you're still getting charges, but the liquor authority has made a predetermination that you are so dangerous, your business is so untrustworthy and potentially detrimental to the health, welfare, and safety of the people of the state, that you cannot be serving alcohol while your charges are pending, while you're getting your charges, while you're trying to settle them, while you're potentially going to a hearing. We can't have you serving alcohol during that period of time. So in those worst of the worst cases, what the liquor authority historically did before COVID is that they would have a meeting at one of their regular board meetings where they would decide whether or not to suspend your license. They would suspend it, agree to suspend it, and then you would get either in the mail or brought to you the next day a suspension order that says you have to stop serving alcohol right now, and you can't serve it again until you get charges. And those charges are resolved one way or another, either by settlement or by going to a hearing. That hasn't changed during COVID. The only thing that's changed during COVID is that the quantity of summary suspensions has really gone up. So for the past, I'd say, month or so, the Liquor Authority Board has been meeting almost every day. If not every day, then almost every day. They usually only meet twice a month. So they've been having special meetings almost every day, where at these meetings, they are suspending anywhere between, a handful to a few dozen licenses and sending out suspension orders. So because of that, we are seeing a lot more people talking about, concerned about, and potentially getting summary suspensions than ever.
I don't have the exact numbers, but I believe since COVID started, a couple of hundred places have been summary suspended statewide. Now, as a percentage, that's not a lot. There's probably, 20 some odd thousand, 25,000 licensed premises throughout the state of New York. There's 14,000 in the city of New York. So, a couple of hundred as a percentage is not a lot. But, you can go through a whole year, pre-COVID, and maybe there's a half a dozen, or a dozen places summary suspended. So to have, anywhere from 150 to 200 places summary suspended in a few month period of time is, is a huge amount. Yeah. Now, couple of points on summary suspension. You've been reading a lot about Liquor Authority, is closing these places down. The Liquor Authority does not have the authority to close any place down, nor do they close any place down. What they do is they take away your right to sell alcohol. Now, if you're a bar, that effectively closes you down. But if you're a restaurant, and you have a busy restaurant business, you could choose, even with a summary suspension, to remain open just without alcohol. I say just, I understand it's not just, but you need to understand that that is your right, even under a summary suspension. And if you choose to remain open, then there are a few things you need to do. You must remove all alcohol from public view, meaning it needs to be taken down to the storage area. It's usually in the basement, lock it up. It can't be sitting at the bar. All those bottles have to go. If you have tap handles for beer, all the tap handles need to be removed. If you are shutting your place down, well, then you don't need to do any of that because you're closed. But it's important, and we always point out to places that the liquor authority only regulates your ability to sell alcohol, not your ability to be in business. And the other thing is, you are still entitled to a faster hearing than you would be entitled to under the first kind of charges that Max talked about, where you get a not necessarily a charge in mail that is not serious enough to amount to a summary suspension. They might offer you a settlement amount or not. You're not guilty on any of those charges until you get to a hearing and there's a decision. That takes time. On a summary suspension, you're entitled to an expedited hearing because you're being closed first and you're getting a hearing second. I do have to say that virtually no one that we've been familiar with who has received a summary suspension so far based on COVID violations that are observed has gone to a hearing. Everybody in one form or another has resolved the charges, and we'll talk about what that means now.
Yeah. So one of the reasons why we, at least in our firm's experience, we haven't seen really anyone choosing to go to a hearing is because it's hard to win at one of these hearings, especially on the COVID-related violations. I mean, if they have observed, documented observations that, your employees, your staff, you violated any of these COVID rules. Now, we may quibble about whether that was deserving of a summary suspension or not. You may think, well, that's a little heavy-handed, and maybe they should have just given me regular charges and not suspended my liquor license immediately. But in terms of whether it happened or not, unless you have, video proof that the inspector got the wrong restaurant or something, it's hard to win at one of those. And of course, if you do exercise your right to a hearing, even though it's a quick hearing, you're still closed until the hearing's over, and then the board reviews the hearing officer's report and makes a final decision. And so,
then ultimately, by the way, that goes back to the same commissioners who've already voted to summary suspend you. So it's not like you get a whole new set of commissioners to decide on your penalty after the hearing.
Right. So for all of those reasons, more often than not, what you're going to want to do, and of course you're going to want to consult with your attorney, before you do, you would take legal advice that's specific to your case. But generally speaking, and what we've seen our clients do is come up with a way to, quote, settle the charges. So in the context of a summary suspension during COVID, understand that the liquor authority is not allowing you to basically have COVID violations be a cost of doing business. So it's not enough just to agree to a monetary settlement amount and move on in life. What the liquor authority is looking for is not only a monetary settlement amount, but also a plan, a specific plan that talks about and commits to, and is going to be followed, what it is that you're doing to make sure that the violations that were previously observed don't happen again. So, and that's very specific to the facts of your case, but just to give a few examples of cases that we've handled, if there was a problem with people, buying alcohol to go, quote, to go, but then really standing, down the block and drinking it in public and causing a big open party scene, that was difficult for you to police. Well, then maybe one of the pieces of the plan is you stop offering alcohol to go for in-person to go and only limit it to people eating in your outdoor dining area or delivery service. If it's a problem with people wearing masks, perhaps a zero tolerance policy for mask failure, for a written zero tolerance policy for failure to comply with mask regulations, maybe even terminating the manager who was responsible for implementing the mask policy and didn't do a good job at it. Very fact specific, but the point is you need to take documented steps to demonstrate how whatever the issue is has been fixed. If you do that, then you're in the world of discussing a monetary penalty with them. And I'm sorry to report that the monetary penalties, even for the most, quote, minor, and no COVID violation is minor, but even the most minor of COVID violations that have resulted in a summary suspension, we haven't seen the Liquor Authority Board accept anything less than $10,000. The range has really gone from $10,000 to $50,000 was the most I've seen. And in some cases, the violations were so egregious that they're not willing to take money. And they say, we don't want to take money to unsuspend your license, to lift the suspension. The only thing that we're interested in is permanently canceling your license. So it's been very harsh and very disturbing for a lot of folks who maybe have very good track records and have now been caught up in a COVID-related violation, now being told that they're looking at least $10,000 in fines and potentially having to fire somebody.
I want to clarify just what Max was talking about as far as what we call remediation. We're talking about particular people, particular businesses that have been summary suspended and the remediation they have to make. So when we say that, in one instance, a business had to discontinue alcohol to go because the place had become such a party scene in the street. We're not talking about the industry ending alcohol to go. The governor's been renewing that every 30 days. The Liquor Authority understands it's a lifeline, for the industry. But there are circumstances and locations where it's not working out so great, and it's turning into a party scene and enough. And I got to say, indoor dining has been held back in New York City because of those early pictures of people drinking in the streets outside of bars and restaurants. There's no question in my mind that we lost a month or so because of that. So we're really talking, about that issue. And the other thing I got to say to the SLA's credit is, and partly because they've had to train a bunch of other inspectors, is that they're doing pretty good inspections. They're taking a lot of pictures. So, the ones that when they've been accused of an employee not wearing a mask and they give us a picture of a bartender, behind the bar not wearing a mask, it's hard to win that at a hearing.
Let's talk about, let me just finish up talking about the process, then Rob, you'll say a few words about the points, the so-called point system. So in terms of how that process winds up, after you have submitted, your license has been summarily suspended, you've now come up with a plan specific to your establishment that you submit to the Liquor Authority in the hopes that they will now be confident that you can go back to serving alcohol without further violations. Hopefully they agree to the penalty that you and their lawyers have discussed and the board signs off on it. Then you have to pay the penalty in full up front before getting your license back. And this does differ from the quote, normal regular process where your license hasn't been suspended, because in that process, you're given lots of time to pay. But when it comes to a summary suspension, you have to pay before you get your license back. So, at the last topic that we're going to get to today in a few more words is, rules and best practices to help you avoid being in this situation. But the purpose of raising the process for you is not only just to help you understand it, but for you to appreciate that this is not a situation you want to be in. Even if you have a good record and the COVID violation that was observed is you think sort of relatively minor, you could still wind up in a scenario where your liquor license has been summarily suspended and you're facing a very large fine in order to get it back. And this whole process at minimum is going to take a few weeks, from when you get the summary suspension order to hiring your lawyer to coming up with the plans, negotiating with the Liquor Authority's lawyers, waiting for the next full board meeting of the Liquor Authority to sign off on your plan, paying the fine and everything. This doesn't happen faster than 2 weeks. It probably usually takes more than that. So it's a situation that many people are in, and obviously there's a lot of concern about trying to avoid getting in that scenario. So
it's not a cost of doing business, is what we want to say. These COVID rules are serious, and the governor is serious about it, and therefore the SLA is serious about it, and you need to be serious about it. And as we go into indoor dining, which it looks like the governor's just announced starting in 2 or 3 weeks, we'll be able to, at reduced capacity. I think at 25% capacity, he's just announced, with a few week review after that. If it's going fine, then we'll be up to 50% capacity. But these are, there's going to be more rules, and more, you're going to need to be even more careful than just dining outside with people dining inside as well,
Right.
making sure they're not moving their tables, or there's not, or four guys sitting at one table is not getting up to stand around, to talk to, four young women at the next table. That's not going to be allowed. It's not allowed outdoors, and it's certainly not going to be allowed indoors. So we know you want to take this seriously, which is why you're on the call, and as do we, as the leading law firm and industry representative. So the point system, you may have heard something about it. It's not like the health department point system, which is a lawfully promulgated, publicly available, inspectors all use it, you have copies of it, 50 some odd rules, each with a certain number of points and condition levels. And if you reach a certain number of points, you get an A, and if you reach a certain number of points, it's a B or C. It's not like that at all. It's an unofficial guidance used for the various inspectors who are going out, especially the non-SLA inspectors who are going out, for them to take a look, a guide for them as to what are particularly egregious, violations, and what are somewhat less egregious violations. But if there's a lot of them, it's significant as well. And what all of this does is it informs these inspectors in certain circumstances to get their report in faster than they might otherwise, because every summary suspension is not automatic. It's reviewed by counsel's office. We have a lot of respect for counsel's office. They do their job professionally. And no matter how many quote points are on this inspection sheet, every summary suspension and every charge still gets reviewed by counsel's office, and a decision is made based on the totality of the circumstances, the prior history. Did you have one or two of these other violations already, COVID-related ones that you pled no contest to and paid a fine? Is this a pattern in practice, et cetera? So we're going to go through, having said all that, we're going to go through, Max is going to go through what they consider to be some of the really most egregious types of COVID violations and some of the less egregious that you still shouldn't be doing.
Yeah, I just also wanted to say about that. I mean, so many people have asked us about this point system because inspectors, especially the non-SLA ones who have been recruited to do SLA inspections, have either left copies of the point system, or if you've gotten charges and you've gotten evidence from the liquor authority, you're seeing these points, and so people rightfully so want to know what it means. But as the message that we want to get across about for anyone who has questions about this so-called point system is that there's no way to responsibly try to game any system or anything like that. Every single SLA or governor's promulgated COVID rules are important, must be followed and observed. There's no way to skirt around them, and there's no sort of strict threshold that if you reach a certain number of points, you get suspended. And therefore, if you don't reach a certain number of points, you don't get suspended. It's not like that at all. If anyone on this call, and I assume everyone is looking understandably and justifiably to make sure that they are not caught up in a summary suspension, the best advice is follow all of the rules in their entirety to the best you can and beyond. We'll talk about best practices shortly. And that's really the only surefire way. Same thing, by the way, with the so-called 3-strike system. That was something that the governor had said at a press conference once. But there's no 3-strike system. You can get your liquor license summarily suspended with 1 strike if the violations that are observed are egregious enough. 2 strikes if they're egregious enough. 4 strikes if you have a lot of little, quote, little violations, but still very serious because they amount to a lot. So there's people want sort of clear rules, and that's appreciated. But when it comes to the threshold for getting a summary suspension, there just aren't clear rules. Your best bet is to follow all the rules as best you can. And, and of course, there are obviously questions about the best ways to follow the rules, which is why people ask. With that said, there are some violations that I call mortal sins. And these are violations that, while all of them are extremely serious, these are ones that could almost guarantee you to get a summary suspension right away. And so while you want to avoid all of these ones you really, in the course of supervising your business, want to pay close attention to. And it's not rocket science. So one of them is people consuming alcohol inside. Now, obviously, with today's announcement, that is going to change. We're going to have time to reflect and adapt and get ready for indoor dining to happen. But between now and when indoor dining does start to happen, and certainly over the past few months, you can't have people consuming alcohol inside. And that's really, the Liquor Authority really considers that very serious. And I see that as the basis for a lot of summary suspensions. Another one is the open container crowding party situation on the street. Now, admittedly, we saw that really decrease once indoor dining opened. If you can remember back to...
You mean once street dining?
Excuse me, once outdoor dining. Yeah, I misspoke. We really saw that decrease after outdoor dining opened. If you can remember back to before June, I think it was June 22nd or something, before outdoor dining opened in New York City, no one had anywhere to go. And so there was a lot of crowding on the streets with open container drinking. But so now that people have places to go, there's even less tolerance for that. So you have a responsibility to ensure that people are not drinking open containers, crowding, socializing on the street, standing up in front of your premises, actually within 100 feet of either side.
And that includes doing, alcohol to go with a wink and a nod, with no top on it, with a straw inside, with, seeing people standing in front of your place, then coming back in for another drink. And there's no wink and a nod here. If you're doing a good alcohol to go business and there's a bunch of people standing out in front of your place on the sidewalk, or they say within 100 feet of front of your place, drinking those drinks that you sold them, then that's an extremely serious violation, especially if there are 10 or more such people.
And also it's related to that, but it's an independent violation, is selling alcohol to go without food. And once we start talking about the rules and best practices, we could review that for folks. But, when it comes to selling alcohol to go, there must be food accompanied with it. And it has to be real food. It can't be a bag of chips or a pretzel or something, a pretzel stick or something like that. And there are places that, have not complied with that, and they've been seen their license summarily suspended. So those are the mortal sins. People drinking indoors, open containers / parties on the street, alcohol to go with no food. All the COVID rules are important, but we've seen any one of those could really be the basis for getting your license summarily suspended. We want to save as much time as possible for answering questions, and I already see it's 1:40. We have a lot to cover. So, I think at this point what I want to do is just going over for everyone here what the rules are as they currently stand, and with some of those rules, we want to add what we think are best practices that go beyond the rules. But if you're looking to be as safe as possible in trying to avoid a summary suspension, these best practices are advisable. And before getting into them, I just want to preface it by saying that, in most states, especially where COVID is spiking, bars have been shut down completely. And in New York, partially because of our numbers have gone down, also partially because of some vagueness in the way that our bars are licensed in New York and the type of licensing category. Bars have been allowed to open as long as they're meeting the food requirements. That's straight from the Liquor Authority's website guidance. If you're a bar, you can open as long as you're meeting the food requirements. But understand that if your business before COVID was really operating a bar, and there's nothing wrong with that, New York City is known for its bars. But during these times and during this period, the best practices may not necessarily align with your pre-COVID method of operation. And the Liquor Authority understands that, and the governor understands that, and they've made the judgment that, that's tolerable because it's in service of public health. And you could argue with them about that if you disagree, but that's what they've decided. So the point of me saying that is when you hear us talk about best practices, you might say to yourself, I can't make a living with those best practices. And that might be the case. And we're not in a perfect world right now. We're not in a perfect situation right now. And if you are operating essentially a bar and trying to do the bare minimum to get past the rules and nothing more, I understand and I sympathize with you, but that might land you a summary suspension, depending on what the inspectors see when they come. So Rob, you want me to get into rules and best practices?
Yeah.
Okay. So let's talk about, we named a few. So let's talk about closing time. Right now, again, until, there's the breaking news today, but until there's indoor dining right now, we're limited to outdoor dining only. Outdoor dining in New York City is required to close at 11. That means that 11 means people are out at 11, not that you stop seating at 11 or you stop serving alcohol at 11. That means, just like anyone who has community board stipulations, you're familiar with this. That means that people are out and no one is there in your outdoor dining area except for staff cleaning up and breaking down. That's the rule. Best practice goes a step further. The best practice is, especially if you're in a place where there is a lot of people getting alcohol to go and then just going down the sidewalk and drinking it on the sidewalk, the best practice is also to stop alcohol to go at 11. So understand the difference. Outdoor dining for your on-premises outdoor seating area, that's the only thing that's required to stop at 11. You're allowed to do alcohol to go until your required closing time. If you have CB stips, whatever that is. But what we've seen in terms of summary suspensions is that there's a lot of people who get summary suspensions where an element of it is that they stopped the outdoor dining at 11, but they still have alcohol to go until 12 or 1. And that generally, in a number of cases, not all, but in a number of cases, what that creates is a scene on the streets where people are drinking open containers. And that can get you a summary suspension. So best practice is to cut off the alcohol to go also at 11.
Especially if you see there's a drinking scene on the street.
Yeah.
If you're in a quiet area where that's never a problem and you're closing at midnight and a few people are taking food, you're a pizza place and they're taking a pizza at 11:30 and they want, some beers, to go with it and they're not drinking in the street, it's not a problem. You have to use your best judgment.
Yes, all of these isn't. All of these are, subject to your own unique circumstances, but these are some sort of general observations and thoughts that we have. Sorry?
We have to move quickly here to get some questions.
Yeah. Drinks with the first order. So what the rules say are that for your on-premises seating area, food must be ordered with the first round of drinks, and it has to be substantial food, meaning a soup, salad, sandwich for each person, or if it's a shareable plate, enough food in that shareable plate to reasonably feed everyone in the group. And as long as they order food with the first order of drinks, then they can get subsequent drinks without food. That's what the rule says. Best practice, we think, should go a step further. Best practice is be mindful that this is supposed to be a dining experience. And so if you have a group of people who ordered, there's 5 people, each of them ordered a sandwich each, and now they're on to their, their 4th or 5th round of drinks, you may want to think about having a policy where you require them to get some more food or you cut them off on the drinks. And that's because written into the Liquor Authority's FAQ on this subject is a catch-all provision that basically says that, we reserve the right to, give you violations if you are not having a dining-like experience, even if you're following the exact letter of the rules. If we think overall, basically what you're doing is making a bar-like drinking experience, we reserve the right to give you violations. So when in doubt, try to make it a food-like, dining-like experience. Try to focus on that more.
And as far as preparing for an inspection, very important that you have and can show the inspector receipts for food for each table. Because when they come, at that moment, that person may not be eating food. And they may say, I don't see any food at these 3 tables. You have to have either a POS or other system where you can immediately show the inspector, these people sat down 32 minutes ago, they ordered sandwiches, they ordered hot dogs, and here's their receipt. That's an important part of preparing, for an inspector. Obviously, general compliance is important as well, but that as far as everybody wearing masks and making sure the tables are properly spaced apart and people aren't standing around at all, in your outdoor areas and eventually in your indoor areas. But have your paperwork ready at a moment's notice to show that food has been ordered.
Okay, so I think we'll just do one more and then we'll get into questions. This is a rule. It's not a best practice. It's a rule. And I've seen this on occasion is don't set up a new bar in the window of your restaurant or if you have, or especially if you have, French doors that open. I've seen some people, for the convenience of staff and probably to attract customers, they set up a temporary bar right there in the window. Not only is that a violation of the rules, it's also against the law. You can't do that. Your bar has to stay where it is. So wherever your bar has been approved by the liquor authority, that's where the alcohol should be coming from. That's where servers should be going to get it. You should not be setting up temporary bars in windows or anything like that. Or
backyards. If you have an approved backyard and your original plan for that was approved by the Community Board and the Liquor Authority did not include a service bar in the backyard, you can't just choose to put a service bar in the backyard.
All right, so we got 15 or so minutes to go. We may go a little over time because I want to get to as many questions as possible. Let me just say before we answer questions, if we don't get to your question, you can feel free to contact us. You can Google us, Pazetsky and Bookman, is how you get our contact information. I'm putting right now my email address in the chat.
There's also this excellent department. New York City put this out. What to expect when you're inspected. I believe we have the website that we can make
a link to that in the chat as well.
And it has a lot of things for you to prepare for if before you are inspected.
So let's get to some questions. All right. So first, do you see any non-COVID related regulations being changed permanently? There are so many that are outdated. No, basic is the answer to that. Everything that's COVID related right now has not been done through normal standard legal notice and comment rulemaking processes. Everything has been done by executive order. The legal basis that makes these executive orders legal and these guidance legal is based on a statute that gives the governor power to do these executive orders during emergencies. And when the emergency is over, the legal underpinning for these executive orders evaporates. And so nothing COVID related has been changed. Nothing COVID related is permanent. With that said, I think that, it makes sense for there to be an effort underway, as whenever COVID ends, to review outdated regulations because our industry really is going to need to recover and we need all the help we can get.
This question concerning, how do you police people outside joining tables together and and making a table that's larger than the rules allow? You can't go over 10, so you just can't allow it. You have waiters, waitress service, you have managers. It's your responsibility. You just can't allow a group to create more than 10.
That's something I've seen a lot of questions about and comes up often. 10 is the limit on groups, and you need to have eyes on your outside. I understand that, if you're busy, you may not have eyes glued to every table at every second, but you need to have all of your staff and your management staff understand that if you have a table that even starts to approach 10, that you need to keep an eye on them to make sure their friends don't show up 10 minutes later and pull up some tables and chairs. It's your business. It's your responsibility. And if they do, you have to reject them.
There's another question here about, the SLA inspector. Did he show, did he show a badge? Did he show proof? Understand a lot of these inspections are taking place undercover. And they're not identifying themselves at all, or they're identifying themselves only after they are done. There's nothing against the law, in doing that. If somebody wants to go into behind the bar or in the back room, any non-public area, then yes, you are entitled and should ask for some sort, of government ID to make sure the person really is working with the government.
But understand, once they've done that and they've shown their ID, you should not be obstructing their inspection. Some people, they've watched Law and Order and they start demanding warrants and stuff like that. You have one of the privileges of having a liquor license is you get inspected. And so, once you know it is an SLA inspector, you have to show them around, and if they want to look inside of things, that's their right to do. And, it doesn't help you. It doesn't help you to start arguing with them or anything like that.
A couple of questions about what do we think about, the outlook on alcohol beverages for takeout and delivery and outdoor dining being extended. We're looking at winter extension right now. The biggest hang up is heating systems. The most common outside of New York City method of heating is propane, sorry. And propane is not legal in New York City. So I don't know whether we're going to be able to do winter dining. But the mayor has committed to starting outdoor dining again next spring. Again, that's by executive order, but that looks good. And as far as the alcohol for delivery, I don't see that ending as long, prior to us being at 100% capacity. Takeout, I think we'll continue as long as there isn't a return to lots of people, drinking in the streets.
There's a question about who in New York City should we specifically reach out to. I assume that question is related to, if you want to speak up to your elected officials and advocate for, indoor dining, seeing if, let's see how indoor dining works out, but any additional changes. Understand that this goes back to one of the first things I said. This is primarily a state-driven process, especially when it comes to the alcohol pieces of it. The city has a role, but really you should be reaching out to your state level representatives. So that means your state senator and your state assembly members, because they're the ones who operate at the state level and, talk to the governor and the liquor authority.
There are a couple questions, both on the chat and in the questions concerning this issue. So I want to go over it again. There is no checklist for quote, egregious or unegregious, and when you will be summarily suspended. It's a totality of the situations. So it could be your first inspection, but they found a whole bunch of stuff going on wrong. They found two people inside, drinking, and your excuse is, well, they were waiting for their food order, and we gave them a drink, and they were consuming inside. Well, that's not an acceptable excuse. Plus, there were a couple of employees that did not have face masks. Plus, there were people standing rather than sitting at an outdoor area. So there could be a whole bunch of these things all put together, which, even though it's your first time, you may not consider it egregious, but in the totality, they do.
Questions about what constitutes, real food. That's the word that I use.
Yeah.
What the law talks about is substantial food. So this, some states like California have tried to make like a 16-page list of all the types of food that count and doesn't count. New York has left it a little more fuzzy. So for your sit-down on-premises eating area, which is currently outdoors only, each customer needs to purchase either a soup, salad, sandwich, or in the FAQs they elaborate that could be something of similar quantity or quality, like wings or nachos, I've been told, hot dogs. These are all things that are substantial. And if they're not each purchasing one and they're purchasing like a shareable plate like nachos, there needs to be enough nachos there for everyone to be able to share. Now, of course, there are all sorts of what ifs like that. For example, my wife and I, we could sit down and share a side salad and be full. Other people, have much bigger appetites. So what is enough food? When in doubt, be conservative, because you don't want to get a summary suspension. You don't want to be caught up in the whole process I just described. So if you think that the food order is a little light, then you should be requiring them to order more. And you could explain, these are legal requirements. We're not making this up. So that's the food requirement. Slice of pizza. Pizza is fine if it's like a real New York slice of pizza. If you're talking about a little tiny little pizza bagel, that's not fine. I mean, use your common sense. Because I saw a question about pizza. So that is that's for your on-premises eating area. For alcohol to go, understand that the type of food they have to order is the same for alcohol to go. It has to be one substantial item. The only difference with alcohol to go is that there's no ratio. So if someone wants to, come pick up an order, or they're using your own delivery service and they want to have delivered to them, one slice of pizza and, two sealed bottles of wine, that's okay if it's alcohol to go. Can someone eat at the bar? So we get a lot of questions about that. So the answer is, and there's been misinformation in the media about that as well. So people are allowed, well, first of all, right now, all you have is outdoor dining. So if you happen to have an outdoor bar, which is rare, but if you're one of the few people with like a rooftop that's already been approved, or you have a legally approved, temporary extension on private property and you have an outdoor bar, people could sit at the bar and eat as long as they are socially distanced and you're meeting the social distancing criteria. That's that 16-page document from the Department of Health. And they're having a dining-like experience. In other words, someone can't, just because it's the bar doesn't mean the food rules evaporate and someone could just sit there ordering drinks and drinking drinks. We're going to have to see, what rules specific to New York City come out for New York dining, which is, of course, hot off the presses. But if it's anything like what the rules were for outdoor dining, then the same thing's going to apply. People need to be socially distanced and having a dining-like experience.
People should not be standing around the tables for any period of time unless they're on their way to the bathroom or back or leaving. Somebody said, an SLA inspector said 1 to 2 minutes. Well, that sounds about right to me. They shouldn't be standing around.
Someone asked a question, when they inspect, do they look at the past day's receipts for food orders? So they don't have strict rules like that. So you need to assume that they might. And if they do ask for them, you have an obligation to turn them over. So if they want to look at your guest checks or a printout from your POS system from the past, day or 2 days or 3 days or whatever, you should be operating under the assumption that they might do that. And so, that's just all the more reason why to make sure that you're not just complying with the rules when an inspector's there, because half the time you're not going to know that they're there because they're going to start off undercover. But at all times, you should be complying with the rules.
If you are lucky enough to have an approved, and I underline approved, outdoor garden, private space, and so let me reiterate, approved meaning it's part of your liquor license premises, not just that you happen to have an outdoor space so you've been using it during COVID. But if you have an approved outdoor space, your hours there are not limited to what your hours are on the New York City street program, which is 11 o'clock. Your hours there are for whatever your approved CB/SLA approved hours are for that outdoor space. So if it's earlier, it's earlier, and if it's later, it's still later.
So someone asked in the chat, how much time period do you have to tell someone to sit down that stands up without a mask? Are they giving a time frame like 1 to 2 minutes? So the answer is no. And, I understand that this is not fair. None of you signed up for this, and none of you are police officers. None of you have guns or badges, but what the liquor authority is enforcing is if someone stands up without a mask, you're in trouble. So you need to, so signage helps, then put up additional signs. But if you do see someone standing up without a mask, you want to immediately go to them, address them. We're in the hospitality business. You want to address them in a way that, doesn't ruin their experience, but also doesn't get your license suspended. And remind them that, they're really not allowed right now to be standing without a mask. And even with a mask, the only times that people are allowed to be standing is if they're going to the bathroom or they're coming or going. Otherwise, people are not allowed to be standing even with masks. So
someone asked, why aren't people drinking in the streets being fined for open container violations? Well, the governor asked that question a lot as well. It's one reason why he's been railing against, quote, compliance in New York City. And the reason is because the state liquor authority and their inspectors only have jurisdiction over you, the licensed businesses. They don't have jurisdiction over individuals. The local police have jurisdiction over the local individuals. They enforce open container laws. And for political and other reasons, New York City Police Department is really not that interested right now in getting into fights with people and issuing summonses for open container laws. So that's why the governor put it on you to enforce that. Fair or not?
Yeah. Let's see, what else do we have? In terms of the sequence, when someone sits down, the sequence of when food versus drinks should be ordered. So before COVID, it was very common for the first thing the server to ask when someone sits down is, can I get a drink order started for you? we shouldn't really be doing that during COVID times. And when someone sits down, you should be trying to take the food and drink order together. If someone wants to order a drink while they are waiting for their food, excuse me, while they're looking at the menu. If someone wants to order a drink while they're looking at the menu, then your policy, I would suggest is, you can get the drink started for them, but you can't place that drink on their table until you've taken their food order and you've put the food order into the POS system. That way, if someone from the liquor authority shows up and they see this person now with a drink on their table, you can go right to the POS system and you could say they just got here, they ordered a drink, and I put their food order in, and now they're just waiting for their food order.
Can someone eat at the bar? Well, unless you have a licensed outdoor bar, the answer is no, because all bars are indoors and there is no indoor. Throughout the rest of the state, where there's been 50% indoor dining, yes, people have been allowed to eat at the bar, but the seats at the bar have to be at least 6 feet apart, or they've accepted plexiglass barriers that extend a certain height and out a certain amount if the seats at the bar are less than 6 feet apart. And that'll be when indoor dining starts. We'll get a lot more information out concerning those things.
Someone's asked, how should I be interacting with inspectors when they come? Understand that inspectors are not coming to get into a fight with you. Most of these inspectors, they're not armed or anything like that. And so, they're not looking to get into a big fight with anybody. So the inspectors generally try to adopt a pleasant, even helpful demeanor. You should understand that this is not like a police officer coming to your personal home where you have a number of rights. You should be cooperative with the inspectors. If they have questions, you should answer their questions. If you don't know the answers, then don't guess. But as soon as the inspection is over, you should speak with a lawyer, because there may be follow-up requests that the inspector has asked for, and you're going to want to make sure that you've spoken with counsel when dealing with follow-up requests. But, adopting an aggressive attitude towards inspectors, not speaking to them, anything like that generally winds up, not really helping your cause. So we're a little over time. I hope this was helpful for folks. There are any number of questions that people legitimately have. If we haven't been able to get to your question, feel free to reach out to us. If you've not joined the Alliance, then certainly join the Alliance. It's a critical organization that needs your help more than ever right now. And we have our contact information. You could Google us, or you could, it's in the chat. But
just one more, Max, before we go. So people are paying cash, how do we keep track of their initial food order? Well, you have to have a paper trail. That's how. Somebody orders a pizza pie, even if they're paying cash, you should have, even if it goes back to the old days where, each order, waiter and waitress hand wrote the order, and there was a dupe. The dupe one went to the kitchen and one went to the waiter or waitress, with the bill. You have to have a paper trail showing that people ordered food.
So thank you once again, everybody. Rob, do you have any closing thoughts before we sign off?
This has been coming up a lot. I'm just going to answer one more question. Can employees eat inside for their lunch break? The answer is, until there's indoor dining, best practices is no. At least in the restaurant portion. An inspector going by doesn't know whether those people are employees or not. He sees people eating indoors. It already starts, a problem. Inspectors have been saying your staff could if they could eat, if there's a downstairs, that's not part of the public space, they're recommending that for the next few weeks until there's indoor dining. It's not a bad idea. So that's it. Look, we couldn't get to all the questions. I hope this was helpful. We can still follow up with more afterwards.
In the chat, if you look, you scroll up in the chat, I've set my email address as well as links to some of the current resources. I know these resources can be dense. This is a complicated period that we're in. The thing that I just want to sign off with saying is, and bar and restaurant owners and staff and managers, whatever, don't hear this enough, but thank you. You're all thanking us, but we want to thank you. I mean, our bars and restaurants are what make New York City what they are. They give character and life to our streets. This is a city that has overcome many, many challenges in the past, from 9/11 to the financial crisis. We will come through this and we will get through this, but it is admittedly a tough time, a confusing time, a very stressful time for people right now. The future is not clear for many people. And so we just want to thank you for continuing to be open, doing your best, continuing to operate. You are essential to New York City, and New York would not be what it is without you. So please stay open and keep doing what you're doing, because we need you.
There is no recovery for New York City without the hospitality industry recovering. We are linked. And if you haven't paid dues this year to the Alliance because you couldn't afford it up until now, if you can now, or when indoor starts in a few weeks, I'm told, people who've been listening while we're talking, it's officially September 30th at 25% capacity. Please pay your dues after that. The Alliance has to pay staff and pay their rent too.
All right, so with that, we're going to sign off. Thank you, everybody, and be well and be safe. Thanks again.